Good morning and welcome to LL97 Compliance Houses of Worship webinar presented by DOB and the New York City Accelerator. I'm Lisa Grayson-Zigma, Deputy Manager of the New York City Accelerator, and very, very happy to have you here today. As we go through the presentation, please note that we will be recording the presentation and we'll make it available with the recording following the webinar today. So let's go into the agenda for today. I'll introduce the speakers and then turn it over to DOB for them to kick off the presentation. So as I mentioned, I'm Lisa Grayson. I'm the Deputy Manager of the Accelerator Program. Our presenters today include Holly Savoya, Andrew McLean, and Aisha Ali from the Accelerator, Holly and Andrew, of course, from DOB. Next slide. So today's agenda includes an overview for LL97 as it relates to houses of worship. We'll talk about, and this will include obviously the DOB submission process and nuances associated with houses of worship. Then we'll segue into the New York City Accelerator assistance that's available to houses of worship. We have about 15 minutes at the end for Q&A, but please also know that you can use the Q&A function in the webinar here to ask questions. We'll do our best to answer them as we go through it, and any overflow we'll also take at the end. So I think that covers it from the agenda and housekeeping items. So with that, I'm going to turn it over to Holly at DOB to dive into the DOB presentation section. Thanks, everyone.
Okay, good morning. Can everyone see my screen?
Yep.
Okay, great. Okay, so this morning we are going to start with the Articles 320 and 321. And when we speak about Article 320 and 321, what we're referring to is the section of the Administrative Code. So generally, Article 320 buildings refer to market rate buildings that have to comply annually with the emissions limits. And Article 321 buildings are for certain types of affordable housing or houses of worship. Okay, so with Local Law 97, what we want to reinforce is that the compliance for 97 takes place at the level of an individual building or a bin, not through the BBL, even though that is what you may see on the covered buildings list. And I have to apologize, I'm going to go through some of these slides rather quickly. It may be old hat for some of you, but I do want to make sure that we cover the basics for those that may be new to this. So some of our resources that you'll find on our website are the covered buildings list, which you'll see it comes with the BBL, and then it may have one or more bins that are associated with that BBL. And then you'll see the compliance pathways all the way to the right. So it starts with CP0 all the way through CP4. And then we also have an FAQ for the CBL, and we have something called the CBL matrix. And what the matrix will do for you is it will give you the documentation that you are required to provide to the DOB if you find that you need to identify one of your buildings as being on a different compliance pathway. And we do need you to do this because there is information about your buildings on your lot that we may not be aware of. So they may be circumstances that we are unknown to us, or there may be changes in what happens on your lot. Okay, so when you have more than one building on your lot, there could be both Article 321 buildings, but there could also be other buildings on that lot. There could be buildings that aren't covered by the law. There could be buildings that are exceptions and do not have to report. One such building would be a garden style apartment, and you should pay particular attention to this because there may be some residential buildings on your lot for housing of religious that may meet this definition. And in that case, they would not have to submit a report. Generally, there probably won't be these other types, but there may be an Article 320 building on your lot as well, such as if you have perhaps a school on the property. In addition to your Article 321 actual house of worship that may be on there. You may also have multiple buildings that may be combined into one report. So we want to discuss all of that for you. So let's go through an example. If the aggregate square footage of all of the buildings on the lot is greater than 50,000 square feet, which comes from DOF, um, then all of the buildings on that lot are pulled into being susceptible to complying with local law 97. So in this case, you have 3 buildings on the lot. One is 26,000, one is 15, and one is 10. Together, that's 51,000. It's greater than 50,000, which means that all the buildings on this lot are covered. However, you have to take a look at this because you may have this one building that's larger, and it may be maybe a school on your building on your property that would be subject to the Article 320 pathway, and that would be due every year on May 1st, barring any extensions or grace periods, and that would start this year. You may have another building, and here it says a city supported cultural institutions group, which is an accepted building, but yours may be a garden style apartment type building that houses some of your religious. You may also have Article 321 buildings, which would be what your house of worship falls into. And maybe there's 2 of them there. And if they share a service, they may be combined into one report. So post 2025, when this building building isn't reporting, and these 2 buildings have satisfied their one-time compliance, then for years in the future, you would only have to comply for this building. Okay, so I am going to, at this point, turn it over to my colleague, Andrew McLean, to explain a little bit further about the covered building list disputes.
Thanks very much, Holly. Hi, everyone. I'm Andrew McLean. I'm also one of Holly's colleagues in the Department of Buildings. So I'm going to talk to you about the dispute process. So as Holly's discussed, not all of the buildings on a lot that are owned by a religious organization will be considered houses of worship. That's because there's a very specific definition of a house of worship under Local Law 97. So that's, as we can see here, a building whose main use or dominant occupancy is classified as occupancy group A3 religious house of worship, which means that greater than 50% of the building is used as assembly space for religious purposes. So we have to be specific about that. So to confirm that with the Department of Buildings, there's a specific process that's been established. It's set out in the Covered Buildings List FAQ, which you'll have a link to, but we're going to go through it a bit as well. So the main requirement is that a registered design professional will certify the floor area measurements of the different use spaces in the building, and where the more than 50% of that building is for religious purposes, assembly space for religious purposes, then it's a house of worship. And there are 2 specific forms that will be used to evidence this to the Department of Buildings, which you can find at the FAQ. Next slide, please. So just to really emphasize this point, all houses of worship need to submit a covered buildings list dispute to the Department of Buildings to show that the building is a house of worship. The Department of Buildings, unless you've already submitted a dispute about this, the Department of Buildings will not know that your building is a house of worship. So you have to send this to us. And this is regardless of whether the covered buildings list already says that compliance pathway 3, which is Article 321, is sort of flagged for your for the tax lot that your building is on. Regardless of that, you still need to submit a dispute telling us that your building is a house of worship. Next slide, please. So the prior process for submitting a dispute was to email us at ghgemissions@buildings.nyc.gov, as of the beginning of last week, we're no longer accepting new disputes that way. So you need to submit a dispute ticket through Beam. And I'm going to talk you through where to do that, how to do that next. But the process, regardless of whether you did it the old way or the new way, is the same. We review the dispute and the documentations. We request more documentation if needed. If needed, we'll get more verification from partner agencies, or that isn't needed for houses of worship. We will then make a determination and inform the applicant, but also update our internal records. Next slide, please. If you have already submitted a dispute, we're working as quickly as we can to resolve it. And if you do submit a dispute in the future, we'll continue to do so. But if a dispute hasn't been resolved by the reporting deadline, building owners should just submit a report along the pathway that they think their building should be subject to. And at the same time, if they need to submit a dispute, if they haven't already done so, submit a dispute with the Beam website. Even if we haven't resolved it yet, just submit along that pathway. And then if we later on disagree with the pathway that has been chosen, we will work with building owners to help them achieve compliance with the correct pathway. We're not looking to penalize it, especially where we haven't yet got back to people about their compliance pathway. Next slide, please. So now I'm going to talk about the platform that you can submit a dispute through. So it's called Beam, and there's a link to it here in the slide, nyc.beamportal.org. So to get to a dispute ticket, which is the ticket that you need to use to do this, you go to Help Desk on the left in the red outline, and then New Ticket on the right in the red outline. Then you'll click the first ticket, 1 Local Law 97 Covered Buildings List Disputes. To emphasize, you do not need an account to do this, and you do not need to have submitted any payment or you don't need to have made a payment to submit a disputes ticket. So this particular ticket doesn't need an account or a payment. Next slide, please. So the first thing that will pop up on this ticket is an outline of the things that you'll need. So basically to identify your building, then to provide any documentation that's needed and answer any questions that we ask. Next slide, please. So the building details are specific to the building here, not to the tax lot. So when you look at the covered buildings list, some details may be a bit different to what you would be entering here. And that's because the covered buildings list is talking about an entire tax lot, which can include multiple buildings, whereas any report is for a single building, or any dispute in this case is for a single building. So you'll want your building address as you see it on the BIS site, the borough block lot, which will be the same in the CBL and for the building. That's the 10-digit borough block lot. The building identification number, that's 7 digits, and that has to be specific to your building as it's seen on BIS and on the CBL. And any other buildings that are covered by this dispute. Now, in this case, you won't want to have any other buildings covered by this dispute. For house of worship, you want to dispute one building at a time to show that they are a house of worship. Next slide, please. So then it'll ask you what sort of dispute you're seeking to do here, and you want to select number 2. I need to update my building's compliance pathway, because you're telling us that your building should be subject to Article 321 as a house of worship. Next slide, please. Then it will ask you to say what compliance pathway it should be on, and you want to select compliance pathway 3, Article 321, one-time compliance. Next slide, please. So then it will give you a number of documentation requirements for different types of Article 321 building. You can see bottom right in the right-hand picture, it is building whose main use or dominant occupancy is classified as occupancy group A3 religious house of worship. That's house of worship. And it'll also give you links to the documentation. So confirm that you understand the documentation and keep going on. So next slide, please. I've missed out a slide here, that's my mistake, but it will ask you what is the reason that your building should be subject to Article 321, and it'll give you a number of options as you saw in the documentation requirements above, and you just scroll to the bottom and say house of worship. Then this will appear, so you can see please submit documentation, upload the documentation we're asking for, and If you want to provide an explanation, although the documentation should be self-explanatory, then you'll submit your ticket. Once your ticket is submitted, we'll process it as quickly as possible and get back to you as soon as we can. But remember, if we don't get back to you before the deadline, just submit a report along the compliance pathway that you are disputing, and we will sort it out later if we disagree. And that's the end of my section. Back over to you, Holly.
Thank you, Andrew. We're just showing you here some examples of this is what the House of Worship verification form looks like. You can find that on our website. Also, when you submit the ticket, there's a link to it. There's the sheet that the verification form sheet that you send out. And then this is sort of like the response that you would get from us when we've made our determination. Okay, so I want to go through some of the timeline dates that are rather important. So the beginning of this month, we began with the launch of the Local Law 97 reporting portal, which you may also hear referred to as BEAM. You can start reporting now. It effectively opens the 6-month reporting period that buildings will have to report. You can also start submitting extension requests if you feel that you need until August 29th. So the next deadline that comes up is the Local Law 84 benchmarking deadline on May 1st. You want to be aware of that. That is the deadline. For Local Law 97, there is a grace period that goes through June 30th. So you can submit up until June 30th without requesting an extension and without receiving a penalty. If you are reporting for Local Law 97 and you request an extension, through that extension has to be in by June 30th, but it'll give you then until August 29th to report. If you get that extension also carries through to Local Law 88. However, if you don't have that extension, Local Law 97 and Local Law 88 are due by June 30th. These are two guides that are on our website. In addition to a number of other guides, we have Article 321 a PECM guide. We have an Article 320 simple building guide. There are lots of guides on our website. These are phenomenal. They give a lot of information. Most of the questions that we get into the department, the answer is right here in these guides. And again, this would be for your house of worship, the Article 321 guide, but for some of the other buildings on your lot, you may want to also look at the 320. Also, if you are a house of worship that is complying with the 2030 limits, you would also want to look at this Article 320 guide. Okay, so for those 320 buildings like schools or those complying with those houses of worship that are complying with the 2030 limits, let's just go over the basics of how the law works. For each building, you get a GHG limit. That limit is arrived at by taking the gross floor area of each of the space types in that building times the emission factor that is for that space type, and then you sum those up. On the other side of the equation, you have all of the fuel usage. And then what you would do is you would take your quantity of fuel that you would use for the reporting year, which would be 2024 for this year. And then you would multiply it by its respective GHG emissions coefficient. You would sum all those up. And then if that side of the equation is higher than the limit side, then you are out of compliance. But if it is lower, then you are good to go. Okay, I just want to go over the difference between gross square feet and gross floor area because we do get a lot of questions about that. Gross square feet is what the DOF measures your building in, and that is what either determines that you are or are not subject to the law. It is not what is used for reporting. For reporting, when you're reporting for 2030 or the 2030 limits for your house of worship, you have to go by gross floor area, and that has to be measured and verified by an RDP. And that is basically the same definition as what is and has been in effect for the benchmarking rule. So just wanted to go over that to be clear. There are deductions that are allowed from the 320 buildings or the houses of worship 321 buildings that are going for the 2030 limits. I'm going to talk about some of them, like GHG offsets and beneficial electrification. I want to point you to the webinars that we have on our website that really go into detail on all of this information. So I know I'm going through it very quickly, but I just want to touch on it so you're aware of it. But I do recommend that you go to our website and look at them. So beneficial electrification. Basically, what that says is that if you take away your fossil fuel equipment and you replace it with high efficiency space conditioning or water heating equipment, you can deduct the emissions that are related to the use of that equipment. So the earlier you do it, you get a double credit. So if you do it before 2027 for those Article 320 buildings that are on your site, your schools or otherwise, you get twice the credit. So this is the coefficient for electricity. Anything you do from 2027 through 2029 for that building in terms of beneficial electrification installation, you would remove whatever electric usage that's associated with that equipment because it's a negative coefficient. And it's twice that coefficient for anything taken up to 2027, even going back to, I believe it's 2021. Same thing can be done for those 321 buildings, houses of worship that are trying to comply with the 2030 limits in 2024. And again, we have a whole webinar on beneficial electrification. There is the earlier that you do this, the more years you get to use that credit in. You don't have to use it, obviously, for those 321 buildings that are going for the 2030 limits. You have to use it. Whatever you've done, you have to use in 2024. But for those 320 buildings, like your schools, you can use it in any 6 of these years if you've done it, if you've installed it in 2024 or earlier. And obviously, it goes down to if you install it as late as 2029, you only have 1 year in this 5-year period that you can use that credit. Okay, there are also offsets that you can take advantage of. I'm not going to go into all of this, but there is a webinar on offsets that we are doing, I believe, next. That we've done, I'm sorry. And you can take a look at that if you miss it. They're all recorded and they're posted on our website. And basically, you can use these offsets to offset 10% of your annual building's emission limits. So these are the qualities that have to be, met. And what happens is it's roughly equivalent to paying the same amount as the violation, but it goes into an affordable housing reinvestment fund, and it's distributed through the HPD's Ready program to buildings that may or may not have to comply with Local Law 97. May not have to comply with Law 97, and it allows you to say that your building is in compliance then if for that 10 if you are under that, if you don't need the whole 10%. Okay, so these are the criteria for the adjustments. There's an external constraint adjustment that's good for 3 years, and that's for a constraint imposed by another provision of law or a physical condition of the building. And then there are also financial constraints for co-ops, condos, and nonprofits and other buildings. And I misspoke before. The 320.7 adjustments is next week on Tuesday if you want to attend. And these are the more information about the financial constraints, but again, there'll be an entire website on this, webinar on this. Okay, getting into some of the enforcement for the Article 320 buildings that might be on your site. Again, those are the schools, not the houses of worship. What happens with those is if you are over your annual emissions limit, you'll be issued a penalty. You can either pay it or fight it in court, or you can enter into mediated resolution. So, in order to enter, when you enter into mediated resolution, be you can have a mitigated penalty. And it's basically an agreement with DOB that says how you are going to be coming into compliance. Um, you can get this if you have an unexpected or unforeseeable event, um, act of God. Please don't pray for that. Um, we will help you otherwise, or good faith efforts. So, what are good faith efforts? Good faith efforts are you submit your 97 report, you submit your 84 report, you submit your 88 report. In addition to that, you have to do one of these six: a decarb plan, you have to show evidence of a general alteration work order that's going to lead to reducing emissions. You can show that you have alterations that are underway for electrification readiness. In future years, you'd have to, show a prior report. Um, and then, if you're a critical facility, you would show how it would negatively affect providing services. Again, our webinars on our website show much more detailed information, so I apologize that I'm going through this rather quickly. But the decarb plan, what it is it's basically, if you're familiar with the Local Law 87 energy efficiency reports, it's basically an energy audit like that, but just a little bit better because it tells us things like, when you're going to do it and what the emissions reductions will be, and basically shows how you're going to come into compliance eventually. Okay, so now going on to the Article 321 compliance part pathways. Those are your houses of worship. There are two pathways you can go. You can go the performance or the prescriptive pathway. The performance pathway is those buildings that are complying with the 2030 emissions limits, using those coefficients in 2024. So you submit a report just like a 2030 just like a 320 building would, but it shows that you're in compliance with the 2030 limits. Once you've done that, that's the one-time compliance. If you elect to go the prescriptive pathway, there are these 13 prescriptive energy conservation measures that you would need to complete. Okay, here are those measures. 9 of them, when you go on to the reporting platform, just 9 of them just require an attestation from the registered design professional or the retro commissioning agent. The 4 of those these highlighted ones do require that some detailed documentation of the inspection is submitted. So these are what those detailed documentation templates look like. And you'll see the 4 of them are here on the bottom. And those are on our website, and you would upload those to your report. Okay, so the penalty framework for 321 properties, those houses of worship. You have to submit the report and you have to demonstrate compliance. And there's a $20,000 combined fee for not doing that. Again, you have access to penalty mitigation on unexpected or unforeseeable event, of course, eligible conservation projects, and mediated resolution with the department. So again, an agreement with the department of how you're going to do what you need to do. So you basically would have to have an attestation that you aren't in compliance. You have to submit your energy benchmarking report, and then you have to have a work plan that's either by an RDP or a CX agent, and that's just showing, depending on which pathway you've chosen, how you're going to get there. So if you've chosen to comply with the 2030 limits in 2024, but you didn't get there, it's about what you're going to do to get there by 2030. And then for the 13 measures, it shows, that you haven't done them all, but it shows how you're going to get them done by the end of the year. Okay, and I just wanted to we've been talking about Beam, which is the local law 97 reporting platform. So I just wanted to go over a little bit about that. That's where you will go in and you'll submit your reports, whether Article 320 or Article 321. If you're applying for an adjustment, um, it's going to pull in data from the Energy Star Portfolio Manager site and also from DOB Now, which you'll go into first to submit your payments. Again, as Andrew mentioned, in order to do a CBL dispute, you do not have to have an account or make payment. This system automates most of the calculations. You just put your inputs in. There are templates for the deductions and credits if you're going through a more complex reporting. And it allows, you're an owner, an owner's rep, or a service provider to input the information, upload the documentation, put their attestations in, and submit the reports. And then any communications regarding enforcement will come through Beam to these 3 email addresses that are entered. Okay, and any questions that you have can be submitted to this email address, beam_LL97@buildings.nyc.gov. And I will turn it over now to the New York City Accelerator and Aisha.
Okay. Thanks, Holly. So I just wanted to go over how NYC Accelerator can help buildings comply with Local Law 97, 88. So what exactly is NYC Accelerator? So it's a city-funded program created to help control costs, meet compliance requirements for local laws, boost building performance, increase energy savings, and reduce carbon emissions across New York City buildings. So we're a completely free program, and we help provide free technical guidance, identify any building upgrade projects specific to your building. We also have a free training program, and we connect building decision makers directly with service providers to implement any decarbonization projects. We also have financial advisors on our team, and they can help identify any financial incentives and financing opportunities for your building. So any building above 5,000 square feet is eligible, and smaller buildings are referred to partner organizations. So you'd get connected with us by either calling us or visiting our website, and you'll receive objective advice customized to your building's needs. There's also no catch, cost, or commitment of any sort. So first you'd learn about the program as you're doing today. Then we'd provide a building assessment, and we'd decide on energy conservation measures tailored to your building. Next, we can get you in touch with service providers that can implement those measures and help identify any incentives that may be applicable for your building. And we'd stay in touch throughout the whole process. So here are some next steps that you can take if you haven't already done so. So the first thing that we would do when we're providing a building assessment is use a local law 97 calculator. We would use this to determine the GFA of your building and then the number of buildings on the lot. We could also use your benchmarking information to see if you have any projected local law 97 penalties and help you plan accordingly. Here's a service provider tool on our website. You can use this to contact any RDPs, registered design professionals, depending on the services that you need. And you can see that you can filter based off of building size, any incentives, certifications, and market sectors. So if you haven't already done so, you can contact us, and we can also see if your building has opportunity to install solar. So solar has an operating life of 25 plus years. It's generally low maintenance, but it does require direct sunlight. We provide free solar feasibility studies. So this is also something that can help when reducing the greenhouse gas emissions associated with your building. So when we're checking for solar viability, what we look for is unobstructed roof area, solar access, the age and the condition of the roof, and the building height. Another resource that a lot of houses of worship have taken advantage of is the Green Jobs Green New York Energy Study. So it's a low-cost energy study that's heavily subsidized by NYSERDA, and it was created to help identify and analyze any opportunities to make the building more efficient. It's generally for not-for-profits that are under 50,000 square feet, and it includes a comprehensive walkthrough of the facility, utility bill analysis, site staff interviews, and it'll give you a report at the end that has a list of energy conservation measures that you can implement. Another study offered by NYSERDA, and this doesn't have any limit on square footage, is the Flex Tech study. And it's comparable to an ASHRAE Level 2 energy audit, and it helps identify and evaluate any opportunities to reduce your energy costs. This can also be helpful if you're planning on completing a local law 87. Every 10 years, buildings over 50,000 square feet must do retro commissioning and complete an energy audit. So this is something that you can use to complete that. Next is benchmarking. Benchmarking is important because you want to make sure that you're submitting your annual energy usage to annual energy usage data to the city every single year. There are also resources that are available that can help you do this. The New York City Sustainability Help Center is a completely free resource that can help you submit your benchmarking. And you do that using EPA Portfolio Manager, and that's a requirement for buildings that are over 25,000 square feet. Next here is all of our contact information. We have our website listed, email, and phone number as well. So that's it from me.
Thanks, Aisha, and thanks, Holly and Andrew. At this point, we'll take questions from the chat that have not yet been addressed. So I'm trying to scroll through them and answer some of them as they're popping up. But let's, I think what I'm seeing here is some confusion about having to submit a dispute to confirm that your building is actually a house of worship. So Holly or Andrew, do you want to just review that and confirm that all do need to do that, and just review that process and question and answer again?
Thanks, Lisa. Yeah, happy to clarify there. So the dispute process, which we went through the BEAM ticket, which is how you can do that now. We need all houses of worship to go through that process to verify to the Department of Buildings that a building is a house of worship. Without that process being gone through, the Department of Buildings doesn't know what pathway that specific building should follow. And so the building may go through the wrong compliance pathway and may be subject to penalties. But if you submit a dispute with us, you will not be subject to those penalties. We'll know that the building is a house of worship. So it's a verification process that all houses of worship have to go through, and it's called the dispute ticket. So that's what where the word dispute comes in. But you can think of it more as a verification process.
Great, thank you, Andrew. I think that probably knocked up a lot of the questions I saw in the chat. Okay, I'm just going to run through these from the top down. How do we know if our house of worship has already filed for an LL84? Is there a place that they can confirm to check their LL84 report?
Well, if they hired a consultant to do their reporting for them, they should know that information.
Okay. And is there is there any way that they can check with the DOB to verify that it was submitted or?
I think you can submit a question to sustainability@buildings.nyc.gov to check, um, for submission for local law 84. However, I will tell you that the deadline is May 1st. So, it may not have been submitted yet. But you can send us a question and we can tell you whether it has or hasn't been. More than likely, it probably hasn't been, because consultants aren't working on that information now. But I would I would encourage them to look into, who they hired to do their benchmarking in prior years, and if they haven't filed for benchmarking in prior years, then send us a note and we will check into it for you. Also want to plug that the Sustainability Help Center is a good resource for benchmarking as well.
Thank you. All right, the next question is, if you have multiple bins, each is less than 25,000 square feet with the same owner, single company or entity, and it's difficult to separate the buildings, in this case, should buildings submit as a complex 320 pathway or simple?
Hi, everybody. I can jump in here. Hi. Nice to see everyone. My name is Beth Golub. I am the Director of Sustainability Policy and Legal Affairs at DOB. And I want to, when it comes to whether you can do a combined report, a helpful resource on this is the 97 report submission process, which is linked to on DOB's website. Combined reports are allowed in the first compliance period, that's only from 2024 to 2029, where the buildings are the same compliance path, have the same owner, and are on the same lot or adjacent lots. Now, a combined report that meets those criteria will still include calculations at the building level, but it would all be combined under one filing fee and one report submission. If those buildings also share energy, and only if the buildings also share energy, then the combined report can be an aggregate emissions report. And so if it was a house of worship and they were doing PACMs, that wouldn't apply. But if it was a house of worship who was showing compliance with the 2030 emissions limit, which is an option under Article 321, that would apply.
Thanks, Beth. Yeah, I
Sure.
think that's helpful. And
I just
yeah, go ahead, Holly. Yep.
I just want to mention that there is going to be a webinar next Friday on combined reporting with ASHRAE New York City. So you can, if you are not on our distribution list and receiving those invitations, drop your name, your address, your email address in the chat, and we will make sure we get you on our distribution list to invite you to those. Or you can find them on the ASHRAE New York City website.
Thanks, Holly. I'm not completely clear on this next question, but I'll give it a shot. It's, will I receive a confirmation / DQE email for benchmarking, even if I don't have a Beam account? And I think there may be a little confusion around how benchmarking feeds into the Beam portal. So
Yep.
somebody
Yes,
want to take that? Yep.
Sure. Hi. The benchmarking does need to land in the Beam portal. Data quality issues are identified and communicated through Beam.
Thank you. Going on to, can you please briefly discuss about EV charging stations, deductions, and what the process will be in Beam?
So this would be a building that is achieving compliance with the emissions limits. DOB has put out service notices that confirm that emissions related to EV chargers are not counted towards the building's annual emissions. For more information about that, you can see our Article 320 guide.
Thank you. The next question is good faith effort applicable for this year only? And how about if any building is subject to delay compliance, for example, the 2026 cohort?
Okay, so again, we are talking about two different compliance paths and compliance requirements. So for buildings who meet the definition of house of worship, those buildings are subject to Article 321, and those buildings do have a penalty mitigation opportunity, which includes submitting a work plan showing when the work will be done. And DOB might offer those buildings a mediated resolution, which is a legally binding contract whereby DOB says, we agree that you can continue on your work plan, and while you do that, we won't issue penalties, and we'll come back to see whether you've achieved your plan as you describe before we issue penalties. That's for Article 321. For Article 320, there are different criteria for good faith efforts. Article 321 is a one-time requirement. Article 320 is an annual requirement. So the good faith effort criteria apply each year. There is one good faith effort option, which is to submit a decarbonization plan. That would need to be submitted this year. There is another good faith effort option under Article 320 that is to show that the building was previously in compliance with the emissions limits but has come out, and the building needs to work to come back into compliance to adjust to this change in circumstance. That would not be available this year. That would be only available after this year. There are other good faith effort options for the Article 320 buildings. We just did the Article 320 penalty mitigation webinar yesterday. So that recording will be up very soon if it's not already. But those options are for Article 320 buildings every year.
Thank you. All right. When requesting an LL97 extension, will that extension request include LL88 and defer the 88 penalty until the submitted 97 decarbonization plan is complete?
Sure, I'm happy to take this also.
Okay, yeah, I'm not sure who wanted to grab that
That's
one. Thank you.
That's fine. So, if a building is subject to both Local Law 97 and Local Law 88 this year, the filing fee will cover both. So a 97 filing fee would cover an 88 filing, and the deadlines are shared. So if a building applies for the extension under 97, that would also apply to the 88 submission. However, if a building is subject to 88 but not Local Law 97 this year, the due date is May 1st with a grace period until June 30th.
Great, thank you. Next question is, if a building is rented to a religious organization for use as a house of worship, does it qualify as a house of worship?
I'll just come in on that.
Thank you.
So house of worship is determined by the space use rather than the ownership. So as long as you can prove that the space in the building is more than 50% for religious assembly, yes, it can qualify as a house of worship. So it doesn't matter that it's rented. However, if it were to stop being rented to this organization and used for a different purpose, then it could stop being subject to Article 321, and it would be subject to whichever compliance pathway the building then became subject to, which would be a matter for the Department of Finance, the Department of Buildings, and the building owner to ascertain.
Okay, great, thank you. Next question is, my building is less than 25,000 square feet. So I need to submit a dispute via Beam that we are too small to have to comply with LL97. And do they need to hire an RDP to do so?
So this depends on the specific conditions. So to be a covered building under Local Law 97, the building is either the only building on its tax lot and it's over 25,000 square feet, or there's more than one building on the tax lot and in aggregate they're greater than 50,000 square feet. So if your building is less than 25,000 square feet and it's the only building on the tax lot, then you need to work with the Department of Finance to change their records regarding the building size. If there's more than one building on the lot, then you need to check whether in aggregate these buildings are greater than 50,000 square feet, because if so, your building will also be subject to Local Law 97.
Great, thank you.
And I'd just like to say something else. While we've had some questions about what sort of registered design professional or what sort of professional can attest to a house of worship verification form. So the verification form lists the different types of professionals. This includes RDPs, registered design professionals, also retro commissioning agents, RCXs. But take a look at the verification form and you'll see the sorts of different sorts of professionals that can attest to it.
Okay, great, thank you. Let's see, okay, where did we wind up here? The next question is, what will be the application process for mediated resolution? Is it in Beam? If so, what is the process? And I know we touched on that, during the presentation, but you may just want to review that again.
Yep, we just did 2 webinars, one focused on Article 321 and one focused on Article 320 that describe the process, which is in Beam. So look for those recordings on DOB's website.
Great, thanks. Next question, if our property is less than 16, I would assume 16,000 square feet, and includes a school, do we need to file this year or just put in a dispute ticket?
So this again depends on the number of buildings on the property. So you need to check the covered buildings list to see whether your property is, and this is the tax lot, is already considered subject to Local Law 97. You need to look at the number of buildings on the tax lot to make sure it's not, or to check whether it's exceeding the 50,000 square foot size threshold that would make all the buildings on that tax lot subject to Local Law 97. And from there, you need to figure out whether you need to send in a dispute. If you do a dispute, you should also file. So which is to say, if your building is currently on the covered buildings list, if your property is on the covered buildings list, yes, file, unless your dispute is resolved before then. But also work with the Department of Finance if you think you need to change the Department of Finance's records regarding your building size. So there's quite a lot of different variables there that might affect your building's compliance.
Yeah, and I should have mentioned this earlier. If you're a house of worship, your account manager is most likely Aisha, who did the presentation for the accelerator section of today's presentation. So reach out to her and she'll help you navigate, some of these issues as it pertains to your particular building. So you can reach out just generally to the accelerator or to Aisha directly if you've already been in touch. All right, so moving on. Let's see, I think there was a couple up here. Is there a checklist that can be provided that will help us understand what we are required to submit or keep track of? And again, I'll plug the accelerator here. We've got a process document that we can share with you, and we'll also can include when we send out the recording. That would be helpful. I'm not sure if I can't recall if there's anything in Beam that kind of gives you the required documentation that you're looking for, before you start the process. Anyone from DOB want to take that?
There are several supportive resources on Beam and also on DOB's website, but we highly recommend engaging with the accelerator and getting that support.
Great, thanks, Beth. Okay, So on average, what is the cost range for a flex tech study? And I guess I can take that. It really depends on a lot of different variables, size and complexity of your buildings. We will probably advise that you apply for NYSERDA support to help offset the cost for that. And again, that's something the Accelerator can help you navigate. Again, reach out to Aisha. She can walk you through the flex tech and other processes to get a flex tech type study completed. Did you want to jump in, Aisha?
Yeah, so it really does depend on the size of the building. And we can help with the application process, and then if you want to learn more about it, I can send over the resources.
Great, thank you. All right. Time for a few more questions here. If a building complies with the sub-metering requirements of Article 311 under LL88, but does not meet the lighting controls requirement, can they submit for LL88 as Article 311 compliant, but Article 310 non-compliant?
Yes, the Article 310 and Article 311 tickets are separate.
Great. Okay, thank you. All right, let me just back up here and see if there are any other questions. And while I'm looking, does DOB have anything more that you'd like to bring up or remind our audience of?
What I would say is, while you may regard yourself as a house of worship, please understand that not all of the buildings on your lot are considered houses of worship. They're very specific definition of over 50% of the space being used for worship. So that is why we are asking that you submit dispute tickets for each of the buildings on your site to tell us what you believe they are, as documented by what we need from you in the verification sheet and form. And that will allow us to help you to comply properly. And so we can avoid having to inadvertently issue you a violation, which you would then have to contest. And it would be just more work for you and also for us. So we want to help you before that happens and get you on the right path so that you are in compliance, and that going forward, if you do have a 320 building on your site, you would only then have to comply for that building going forward, and you would be done.
Thanks for that clarification. One more question just came in that may be slightly off topic, but we'll ask it anyway. It's regarding how does one go about filing for renewal of an expired not-for-profit permit? Probably not your division. No. Okay.
I would just say that I to the extent that DOB requires proof of a nonprofit status, it's through DOF. So DOF might be a good DOF materials and resources are where we confirm nonprofit status. So you may want to speak to DOF about that.
Great, thank you. We have 2 minutes left. So again, I'm going to throw it back to DOB. Andrew, Holly, Beth, is there anything more that you would like to share or remind the audience of? And if not, Aisha, anything that, again, as I mentioned earlier, Aisha's our House of Worship specialist on our team. So she's your point of contact to help you navigate all things related to your compliance pathways and options.
I dropped my email in the chat just in case anybody wants to contact me. If you have any questions, let me know. And then there's also some information if you need any help benchmarking. The Sustainability Help Center can help you with that as well.
Super, good reminder. All right, well, I think we've covered all the questions. Again, we will be providing a copy of the presentation and a recording. We are here to help, so don't be shy, reach out to our program, and we'll make sure you get the resources you need to do your submissions. So thanks, everyone. Have a great day, and look forward to seeing you on future webinars. Take care. Bye-bye.